Welcome back to the deep dive. This is where we sift through all the dense policy, the legislative overhauls, the court rule changes to bring you what you really need to know, and fast.
And today we are really jumping into a surprisingly dynamic and I think politically charged world.
That's right, alternative dispute resolution, or ADR, and specifically mediation. We're focusing on 2025.
And what a landmark year it was. I mean, for most people, ADR sounds technical, maybe even a little bit boring.
Yeah, a little dry.
Exactly. But this deep dive is so crucial because 2025 was the year when the rules that govern very common conflicts, I mean, everything from federal labor strikes all the way down to your consumer lemon law case, were just radically rewritten.
You've got a whole stack of sources in front of us. We have federal executive orders, emergency state legislation, really detailed, granular changes to court procedures.
Right.
So our mission today is to decode this seismic shift. We really want you to walk away from this understanding three things. Who gets to mediate your disputes? When you are legally required to mediate, and what actually determines whether your conflict is going to cost you a ton of time and money in court.
Or if it gets settled quickly and, privately.
Exactly. Okay, let's unpack this. And I think we have to start with the most dramatic, the highest stakes development of the year.
Oh, absolutely. The federal mediation crisis.
The one involving the Federal Mediation and Conciliation Service.
That whole event, which really unfolded in the spring of 2025, that was the moment. It truly brought the importance of, mediation infrastructure right into the national spotlight.
So for anyone who isn't familiar, what exactly is the FMCS?
The FMCS, or Federal Mediation and Conciliation Service, is the organization mandated by the Taft-Hartley Act. You can think of it as the quiet backbone of labor management relations in the U.S.
The quiet backbone, I like that.
It is. They provide these neutral, really expert mediators to help unions and companies hammer out contracts. And the big thing is they prevent these incredibly disruptive work stoppages.
And the threat to this whole institution was very, very real. In March of 2025, the administration issued an executive order.
Yes. And it was aiming for either the outright closure or, at the very least, a severe functional reduction of the FMCS.
And this wasn't just framed as some simple budget cut, right?
Oh, not at all. It was seen by many, many experts as a direct attempt to dismantle a core piece of federal labor infrastructure. I mean, something that has been operating since 1947.
Wow.
The fallout was just immediate. Experts were warning that if that order had actually succeeded, it would have created this huge vacuum in the collective bargaining process.
So what does that look like in practice? A vacuum?
Well, imagine contract negotiations, let's say between a major airline and its pilots union.
Okay, high stakes.
Very high stakes.
Right.
Or a large manufacturing plant and its entire workforce. Without a neutral statutory federal mediator to shepherd those incredibly complex talks, these labor disputes would have nowhere to go.
So just straight to court.
Straight to costly litigation or, far worse, a dramatic increase in crippling strikes.
But that threat was stopped pretty quickly.
Very swiftly, yes. In a really pivotal moment for the FMCS, less than 2 months later, a federal judge in the District of Rhode Island.
A state with a deep labor history, it's worth noting.
A very deep labor history. That judge enjoined the order.
And the ruling was pretty definitive, as I recall.
It was unequivocal. The judge's ruling on May 6, 2025, found that the FMCS, and I'm quoting here, must be reinstated.
Wow.
And it specifically referenced the agency's outsized role in maintaining economic stability by preventing strikes.
So the judge's reasoning wasn't just about bureaucratic procedure, it was about the real-world economic impact.
Precisely. It focused less on the mandate and more on the agency's crucial function as, a peacekeeper, an economic stabilizer. It was this clear judicial recognition that the service provides an essential public good.
Now, the moment that executive order was announced back in March, there was an immediate, very organized reaction, wasn't there?
Absolutely. The unions, the labor scholars, they immediately filed suit. They argued the order was just undermining critical economic stability.
And the FMCS itself didn't just sit back and wait.
No, and this was notable. The FMCS issued a public statement, even before the injunction. They were confirming to their stakeholders, the businesses and unions they serve, that they intended to continue operations.
That's a bold move.
It was. And that action, combined with the speed of the injunction, it just showed this wide consensus that this service is, Indispensable.
And this is where it gets really interesting, especially if you look at government programs through the lens of, say, return on investment.
The financial argument.
The financial argument for keeping the FMCS running proved to be the aha moment for a lot of observers.
It really was a massive coalition, and this is the key part. It included both labor organizations and management associations.
Both sides.
Both sides. And they pointed out the staggering efficiency of the agency. The numbers are just phenomenal. The FMCS operates on a relatively modest annual budget, something around $53 million.
Okay, $53 million. That sounds like a lot, but in federal terms, it's not huge.
It's a rounding error for some agencies. Yet this coalition calculated that the service yields an estimated return of over $500 million annually.
Wait, say that again. $500 million in savings for a $53 million investment.
That's the number.
That's nearly a 10-to-1 return. I mean, how is that even calculated? How do you quantify strike avoidance savings?
That's a good question. It's calculated by estimating the total economic cost of a major work stoppage. So you're talking about the lost wages for all the workers, the lost productivity and revenue for the companies.
And the ripple effects, I imagine, the supply chain, local businesses.
Exactly, all of that.
Yep.
So when an FMCS mediator successfully prevents a strike at, say, a major shipping port or a big manufacturing hub, that saving is just exponentially larger than the mediator's salary.
So it illustrates that this kind of mediation, especially in these high-stakes labor situations, it isn't overhead.
Not at all. It's preventative economic medicine. By preventing a protracted strike, they're ensuring the continuity of business, the continuity of wages. It just demonstrates the FMCS's immense value far beyond just, legal compliance.
Okay, so while the federal government was trying to gut this system, and before the judge even had a chance to intervene, the states realized something.
They realized they couldn't afford to wait.
Right. They saw that federal safety net fraying, and they immediately started working to backfill that potential void.
That's exactly right. States are keenly aware that labor stability is absolutely critical for attracting and retaining businesses. They move so rapidly to ensure that if the FMCS were truly crippled, collective bargaining in their jurisdictions wouldn't just seize up.
And that urgency drove a pretty proactive effort to maintain that neutral mediation dialogue.
It did.
So which states moved the quickest here? Which ones jumped in to increase their own mediator capacity to handle what they thought would be a surge in demand?
Michigan and California were definitely the leaders. Michigan, I think, recognizing the vulnerability of its public sector unions, announced plans as early as April 2025.
Through its labor department.
Yes, to hire additional mediators dedicated specifically to public sector bargaining disputes. It was just a clear signal that the state intended to carry that load if the federal government stepped back.
And California, which is often a trendsetter in labor matters, took a similar path but broadened the scope.
Precisely. California's Public Employment Relations Board, or PERB, that's their state agency for handling these labor management issues, publicly stated they were stepping up to offer significantly more mediation services. And this expansion covered both public sector issues and also private sector labor disputes. They recognized that companies and unions that had been relying on the FMCS would suddenly need another source of neutral help.
So these were direct, urgent responses.
Completely. And focused entirely on ensuring continuity of function.
So the moves in Michigan and California, they were about increasing the supply of mediators. But then you have Washington State, which added this really fascinating, kind of innovative financial incentive layer to the whole process.
Oh, this is where policy gets really clever.
It was a law passed in May 2025.
Yes. And Washington's law directly ties the availability of state-funded unemployment benefits for striking or locked-out workers to the availability of mediation. It's a really elegant, self-sustaining mechanism.
Okay, walk me through the mechanics of that. How exactly does the state use unemployment benefits as a lever to push parties toward mediation?
So the law requires the state to formally notify employers and unions about the voluntary mediation that's available through their state agency, the Public Employment Relations Commission, or PERC.
Okay, so that's step one, notification.
Right. But here's the punchline. The state permits charging fees to the employer, or the union, or both, to fund this mediation infrastructure whenever strike-related unemployment benefits are being paid out.
Wow, that is highly sophisticated. So the state is basically saying, look, we'll pay the unemployment benefits to maintain economic peace.
But if you didn't use the mediation we provided to you,
well, we're going to charge you to recoup the cost of that failure to mediate. Is that it?
that is the core logic, yes. It shifts the financial burden right back to the disputing parties for failing to use the state-provided resolution mechanism. It creates this very palpable financial disincentive for labor disputes to escalate into strikes.
Because both sides know that by not mediating, they're just increasing their own financial liability down the road.
Exactly. The incentive is powerful. Resolve it at the table, or you're going to pay the economic consequences through the unemployment system.
And this action was signed into law on May 19th. It essentially weaponizes the unemployment system to ensure labor peace.
A strong word, but it fits.
So looking at this whole federal-state interaction, what's the big takeaway for our listener?
The takeaway is crystal clear. Neutral, government-supported labor mediation is viewed across the political spectrum, and certainly across state lines, as a non-negotiable piece of modern economic infrastructure.
So these state efforts, hiring more people, creating financial incentives, they were all about trying to retain a vibrant FMCS function,
Right.
even if the actual federal agency disappeared.
That's it. So for you, the listener, this means that whether you're an employer facing contract talks or an employee who depends on a stable work environment, the necessary infrastructure to keep those talks peaceful was defended. And in some states, like Washington, it was significantly strengthened in 2025.
That context just makes the sheer necessity of this service undeniable. Okay, but now, let's pivot. Let's move from federal labor policy and look at quality control.
Okay.
This brings us to our next major theme. Raising the bar on professional standards and trying to achieve some uniformity in the practice of mediation itself.
This is really the maturation phase of dispute resolution. As our society relies more and more heavily on mediation to resolve, everything from business partnerships to divorces.
Everything.
The people providing that service, they just can't operate unregulated. States are realizing that they have to provide some consumer assurance about the mediator's qualifications and their ethical standards.
And California, as often happens, took the most aggressive step here with its certification program, SB 940. It went into effect January 1st, 2025.
And this established a voluntary statewide certification program for private mediators.
This is huge for California, isn't it?
It's massive. For 2025, anyone could basically just hang a shingle and declare themselves a mediator with zero oversight. Now, SB 940 tasks the state bar, the same body that regulates attorneys, with overseeing the standards.
Standards for what, specifically?
For training, experience, ethics, and creating a formal public complaint process.
And it's important to keep stressing that this is voluntary, right? So if you don't get certified, you can still mediate. You just can't carry that state seal of approval.
Exactly. It's meant to be a gold standard, not a barrier to entry. If you're a consumer out there looking for a mediator, choosing someone who is state bar certified gives you this verifiable minimum baseline of professionalism.
Let's look at the specific requirements, the gatekeeping that was proposed under these new rules. What does a mediator actually have to prove to get this certification?
For new applicants, the proposed rules mandate a baseline of 40 hours of basic mediation training. This is really foundational skills work.
Okay, 40 hours.
And on top of that, they have to demonstrate significant recent field experience. So involvement in at least 6 mediated cases in the last 2 years.
And they have to follow the bar's ethics rules.
Right. They have to adhere to the bar's ethical guidelines for neutrals.
That sounds reasonable for new people coming into the field, but you mentioned a grandfathering clause. That seems pretty necessary given how many experienced mediators are already practicing in California.
Oh, it is absolutely crucial for practitioner acceptance. The clause ensures that highly experienced neutrals, people who have been mediating successfully for 20, 30 years, they don't have to go sit through some basic training course.
So the system recognizes that years of practice can be equivalent to formal training.
Exactly. It recognizes that lengthy, documented practice in the field is just as valuable.
So this marks California's first real formal regulation of private mediators. But I understand this was actually highly controversial. Why would professional mediators object to a certification that, on its face, seems to validate their profession?
And you just hit on the core conflict of professionalization. While the bar and many advocates, they welcome this initiative, arguing it raises the floor for everyone, a significant number of veteran mediators strongly objected.
What was their contention?
Their argument was that mandatory training, even with these grandfathering exceptions, it diminishes the value of lived experience.
So their argument boiled down to something like, look, I have hundreds of successful cases under my belt. Why do I need a piece of paper or some mandatory continuing education to prove I'm competent?
Precisely. They felt that years of demonstrated success should be the standard. and that forcing seasoned practitioners back into a classroom was just bureaucratic overreach.
But what's the counter argument to that?
The counterargument is that certification, even if it's voluntary, provides a consistent set of ethical standards and, crucially, a public complaint mechanism.
Which protects the client.
It protects the client, regardless of how experienced the mediator is. The fact that the process is voluntary and that it's overseen by the bar suggests California is trying to find that balance between setting a high benchmark and still respecting the existing pool of talent.
That's a thoughtful approach to quality control. Now, let's shift east. Let's go to Connecticut, which tackles standardization in a different way. Not by focusing on the individual practitioner, but by setting clear statutory rules for the process itself.
That's right. They adopted two major pieces of uniform legislation.
Let's start with the first one, the Uniform Mediation Act, or UMA.
Connecticut's adoption of the UMA, which was effective October 1st, 2025, is just a tectonic shift for confidentiality in the state. By joining 12 other states, Connecticut created strong statutory clarity where there was just ambiguity before.
Okay, so for the layperson, why is statutory clarity on confidentiality so incredibly important in mediation?
Confidentiality is the absolute lifeblood of mediation. If parties are afraid that what they say, their concessions, their creative solutions, maybe even their apologies, can be used against them in court later,
They won't talk.
they won't talk, honestly. The UMA provides what you could call an ironclad privilege. It makes all mediation communications confidential and completely barred from evidence in any subsequent legal proceeding.
And that applies across the board.
Equally to voluntary mediations and court-ordered ones. It just removed years of reliance on sometimes confusing case law and replaced it with a clear, simple legislative declaration.
So it protects the content of the conversation. But you noted that in law, there are always exceptions. What are some of the key mandatory exceptions under the UMA?
The UMA is definitely designed to protect communication, but not to shelter illegal or harmful behavior. So key exceptions would include things like evidence of a threat of violence or bodily injury,
That makes sense.
or communications that are used to prove a mediator committed some kind of professional misconduct. And also, of course, if all the parties expressly agree to waive confidentiality, then the privilege is nullified.
So what are the practical day-to-day implications of Connecticut adopting the UMA? What changes for practitioners?
It creates several new requirements. First, mediators now have to be incredibly rigorous in checking for conflicts of interest before they even take a case, given the statutory weight of this privilege. Second, it explicitly confirms that parties have the right to bring their attorneys to mediation. And crucially, for lawyers practicing in Connecticut, they now have to proactively update their confidentiality agreements with their clients to make sure they fully align with these new, strict UMA rules.
Making sure the client really understands the scope and the limits of the privilege.
Exactly.
Now, Connecticut didn't stop with mediation. They also adopted the Uniform Collaborative Law Act, or UCLA, which also went into effect on October 1st.
Yes.
And this is often confused with mediation. Can you just clarify the fundamental difference for us?
This is a vital distinction, and it's really why the UCLA is such a significant addition. Mediation uses a single, neutral third party, the mediator, to help parties negotiate toward their own solution.
Right.
Collaborative law, on the other hand, is not about using a neutral facilitator at all. It's a contractual framework for negotiation that is designed to avoid litigation entirely.
What does that contractual framework actually look like?
It's all centered on a binding participation agreement. The parties and their attorneys, they all commit to negotiating outside of court.
And the big deterrent, the defining feature you mentioned, is the commitment.
It's the massive deterrent. If the negotiations fail and either party decides they have to resort to litigation, both attorneys must withdraw from the case.
Wow. That is a severe consequence. It forces an incredible amount of good faith, doesn't it?
It really does.
I mean, if I'm a client in some contentious divorce, and I know that my lawyer, who knows all the intimate details of my case, has to abandon me if I walk away from the negotiation table.
You are highly incentivized to settle.
Oh, highly incentivized.
Absolutely. The cost of failing is enormous. Not just financially, but in terms of time and momentum. The client would have to hire a whole new legal team, pay the costs of onboarding them, and then wait for them to catch up on a potentially years-long dispute. It just creates this powerful commitment to finding consensus.
And this framework is particularly suited for family disputes, I believe.
Yes, especially divorce. Collaborative law really encourages a multidisciplinary team approach.
What does that mean, a multidisciplinary team?
It means the client's team often includes, in addition to their lawyers, financial neutrals, divorce coaches, and even child specialists. These specialists provide expert, non-adversarial advice that helps the parties reach a more holistic settlement, not just a purely legal one.
So legal sources are expecting this to really take off in Connecticut.
Widely. They predict that the adoption of the UCLA will lead to a massive expansion of collaborative law use in Connecticut as this trusted statutory alternative to adversarial litigation.
Okay, so summarizing this whole push for professional standards, we see California creating a high voluntary benchmark for individual mediator competency.
Right.
And then you have Connecticut establishing strong, uniform rules for confidentiality with the UMA, while also introducing this new, robust framework for negotiation with the UCLA.
The clear message is that state governments are viewing ADR as a fundamental, really maturing component of the justice system.
Something worthy of standardization.
It's exactly. High quality and consistency are the goals. Without that uniformity, ADR risks becoming a kind of Wild West that the public just can't trust. These states are making it clear. If it's going to be part of the legal process, it has to be dependable.
That sets the stage perfectly for our final and maybe our most immediately relevant section. Sector-specific shakeups.
Yes.
This is where we examine those targeted rule changes that directly impact the everyday disputes you might actually encounter, from buying a car to dealing with your neighbor's grievances.
And these sector-specific laws are so crucial because they represent these highly focused battles between consumer rights advocates and specific industry lobbyists.
So you see mediation expanded in one area,
Only to be curtailed in another, based entirely on who had the strongest voice in the state capitol that year.
So let's start with California's really contentious lemon law mediation saga. This involves two linked bills, AB 1755 and then SB 26. What was the problem AB 1755 is trying to solve in the first place?
The background here is critical. California courts were just being inundated with Song-Beverly or lemon law cases.
These are lawsuits when a new car has defects the manufacturer can't fix.
Right, after a reasonable number of attempts. And the sheer volume was just clogging the dockets.
Yeah.
So AB 1755, which was signed into law, was the legislative response. It instituted an expedited early mediation regime for these lawsuits, effective January 1st, 2025.
And what did the original bill, AB 1755, require the parties to do?
It was very decisive. It mandated that mediation must be scheduled within 90 days of the manufacturer filing its answer to the lawsuit.
Okay, 90 days.
And it had to be completed within 150 days. And to give the process real teeth, it stayed most formal discovery. So depositions, interrogatories, document requests, until the mediation was concluded.
The idea was simple then. Force both the consumer's lawyer and the manufacturer's lawyer to the table quickly?
Before they could spend years and, tens of thousands of dollars on discovery.
That sounds like a powerful legislative victory for judicial efficiency and, the consumer's right to a fast resolution. But
as we often see, decisiveness is followed by intense pushback.
the ultimate example of lobbying power.
It was. The auto industry mobilized immediately. Our sources noted just intense pressure and spending by major manufacturers GM, Ford, arguing that the mandatory nature of the deadlines was just unworkable for their compliance departments nationwide.
And that pressure led directly to the critical amendment.
SB 26, which was signed into law just a few months later on April 2, 2025.
And SB 26 completely changed the trajectory of the reform. It made the expedited procedures opt-in for the manufacturers.
A complete gutting of the mandatory nature of the bill. Under SB 26, that strict 90-day mediation deadline and the stay on discovery, it only applies to companies that proactively file an election with the Department of Consumer Affairs.
So if a manufacturer chooses not to file that election.
They just revert to the old, slow, discovery-heavy process.
So let me get this straight. If I buy a car from manufacturer A who opted in, I get a fast track to mediation. But if I buy an identical car from manufacturer B who didn't, I'm stuck in the long, expensive litigation process.
That is the confusing reality of the bifurcated system created by SB 26. Consumer advocates were justifiably outraged. They called it a deliberate weakening of consumer protection.
Their argument being that a consumer's access to an efficient resolution shouldn't depend on the choice of the company that sold them a defective product.
Exactly. While industry lobbyists claimed it provided necessary balance and choice, the consensus among legal observers was that this just greatly diluted the efficiency goals of the original legislation.
It's a really clear illustration of mediation being introduced as a necessary tool, only to be rendered optional by subsequent political pressure.
Absolutely.
Okay, now let's travel across the country to Florida, which is simultaneously trying to eliminate mandatory mediation in one contentious area while streamlining the process in another.
Florida presents a really fascinating policy contradiction, especially with the ongoing debate surrounding homeowners association, or HOA, disputes.
Let's focus on the controversial proposal first. The potential elimination of HOA mediation through HB 657, it was pending consideration late in 2025. What's the current system that this bill aims to dismantle?
Right now, Florida law mandates that most disputes between a homeowner and their association, and this can be anything from a fine for a misplaced garbage bin to an argument over community amenities.
The small stuff and the big stuff.
All of it. It must pass through mandatory pre-suit mediation. This acts as a required cooling-off period and a filter, forcing resolution talks before either side can file an expensive lawsuit.
And the proposal is to get rid of that requirement entirely and replace it with a new statewide community associations court. What's the argument from supporters of this change?
Supporters, and this includes some homeowner advocacy groups, they argue that mandatory mediation is often just a wasteful detour. Their core point is that mediators don't impose decisions. They only facilitate negotiation.
So if the parties are just fundamentally entrenched.
Exactly. Say, over a long-term architectural change, mediation just delays the inevitable litigation and adds unnecessary cost. They champion this new community associations court as a path to get to the decision maker a lot faster.
They want a judge, not a facilitator.
That's it.
That argument for efficiency is compelling on paper. But let's use a hypothetical that our listener might face. Imagine a really trivial but frustrating disagreement. Your neighbor's fence is too high, or there's a mandatory special assessment you disagree with.
Right.
If you skip the structured negotiation of mediation, doesn't that remove the one opportunity you have to resolve it without immediately escalating to a formal adversarial court process?
That is exactly the strong counter-argument mounted by the opponents, which includes a lot of HOA managers and long-term association residents. They warn that eliminating mediation removes a vital pressure valve.
A pressure valve.
Mediation not only filters out trivial claims, but also provides a structured environment where the emotional temperature can be lowered. If the very first step in resolving a dispute over a pool rule is now filing a lawsuit in a specialized court, opponents fear that the new courts will be immediately overloaded.
Overloaded with small, highly emotional disputes.
Leading to costlier and more fragmented litigation overall. Mediation prevents these small disagreements from becoming permanent legal scars in a community.
This debate really highlights the central tension in ADR, doesn't it? Is the goal simply efficiency, or is it comprehensive communication and maybe improved community relations?
It's both, and that balance is so delicate. Removing mediation might increase the speed to judgment for a few major cases, but it risks making the system slower and vastly more expensive for the majority of these minor, yet very common, HOA squabbles.
The policy decision here really determines the quality of life in thousands of Florida communities.
It really does.
Now, while that controversy is swirling, Florida also implemented a technical rule change that was aimed entirely at streamlining the execution of settlements. This involves a revision to the Supreme Court Rule 1.730, which went into effect April 1st, 2025.
This is a subtle but critically important detail for practitioners and litigants involved in complex civil cases, especially those handled by insurance. The court deleted the requirement that attorneys must also sign a mediated settlement agreement.
Okay, why was the attorney signature requirement a problem, and how does removing it help?
It was a practical enforcement headache. In cases involving insurance defense, often the actual insured party, the defendant, doesn't even attend the mediation.
Or they're there, but the insurance rep is doing all the talking.
Exactly. The insurance representative has a full settlement authority to negotiate. Under the old rule, if the attorney wasn't present, or if there was confusion over who had the necessary authority to bind the insured, the settlement agreement could be challenged later on.
So the revision clarifies that the only essential signature is that of the party, or, crucially, their authorized representative with full settlement authority, like an insurance adjuster.
Exactly. The revision mandates that these authorized representatives, like insurers, must be accompanied by a certificate of authority to prove they have the power to settle.
So the rule change just formalized this certificate mechanism.
It did, and it resolved the lingering legal ambiguity over who must sign, making mediated agreements immediately easier to enforce and aligning the court rule with existing Florida statute. It was a clear win for practical legal efficiency.
Okay, let's broaden our scope now and cover a few other targeted reforms aimed at accelerating dispute resolution in these high-volume, often frustrating sectors. Let's start with Texas health billing.
Oh, the issue of surprise medical bills is something everyone can relate to.
It's a huge consumer pain point.
It is. And Texas used legislative action, SB 2544, to ensure that the resolution process for these bills just doesn't drag on indefinitely. The law specifically tightened the timeline for mandatory mediation of certain out-of-network medical billing disputes.
What's a new critical deadline implemented under the insurance code?
For services rendered on or after September 1st, 2025, the provider or the insurer, they have to request mediation within a firm deadline of 180 days of the first insurer payment.
180 days.
And if they miss that deadline, they lose the right to use the state's mandatory mediation program for that claim.
A 180-day deadline sounds long, but in the world of complex health billing, that's actually very aggressive, isn't it?
It is, especially when you think about the complexity involved in determining what is a reasonable and customary payment for an out-of-network service. The intent is clear: to force both parties, the hospital system and the insurance company, to the mediation table quickly.
Before the dispute just lingers for years and leaves the patient in limbo, fearing a huge collection action.
Exactly. And the law also had implications for old, lingering bills.
How so?
The bill included a critical provision for finality. Any out-of-network claim that was older than 120 days after the enactment date of the law became ineligible for the Texas mediation program.
So it was an effective way to wipe the slate clean.
And ensure the program focuses only on recent disputes, creating a finite window for resolution and minimizing that long-term patient uncertainty.
Moving from financial disputes to family matters, New York is tackling child custody and visitation disputes with a proposed Child Custody Reform Act.
Yes, A3822S 5572. This pending legislation is attempting to achieve statewide standardization in how custody and visitation are resolved using ADR.
Because historically, these procedures have varied widely from court to court, maybe even judge to judge, across New York.
That's right. This act would ensure uniformity.
So how would it institutionalize ADR?
It mandates presumptive mediation. So after an initial planning conference with the judge and all the parties, where the judge helps define the issues and potential pathways, mediation becomes the default next step.
And if the bill is enacted?
Then the chief administrator of courts would be required to implement uniform mediation procedures and case plans across all family courts in the state.
That's a strong institutional move toward early resolution. But in child custody matters, the potential for domestic abuse is always a critical concern that mediation might overlook.
And that is the essential caveat that advocates rightly stress. The bill explicitly presumes mediation only unless inappropriate, and it requires rigorous screening for issues like domestic violence or child abuse.
So safety has to override efficiency.
It must. But assuming proper safety protocols are implemented, the expected implication is a significant increase in early settlements and a reduction in the number of these contested, emotionally draining hearings. It really echoes a national shift toward presumptive custody mediation.
We focused heavily on government legislation, but private institutional changes also influence the landscape. The American Arbitration Association, the AAA, introduced new voluntary consumer mediation procedures.
That's right. Effective April 1st, 2025, the AAA implemented new voluntary procedures specifically tailored for consumer disputes nationwide, provided the claim is valued under $75,000.
So why would a private body like the AAA feel the need to formalize this? And why should consumers care?
Well, the AAA is the leading institutional body for private dispute resolution. By formalizing these procedures, they provide a standardized, respected forum for businesses to handle consumer complaints outside of litigation.
So it's a strategic, proactive move by certain industries.
I think so, yes. The consumer finance and retail sectors. Instead of waiting for potentially restrictive regulation concerning mandatory arbitration, the industry is providing a streamlined mediation avenue with limited discovery rules and clear timelines.
And for the consumer?
For the consumer, it provides a faster, cheaper alternative than filing a lawsuit, assuming, of course, that the business agrees to participate.
And finally, we need to touch on the unglamorous but essential work of administrative streamlining. We saw this in North Carolina and New Jersey.
Right. These aren't contentious battles, but they ensure the plumbing of the justice system works consistently. If the rules are contradictory or outdated, the entire system just grinds to a halt.
So in North Carolina, effective January 6, 2025, the Supreme Court approved a comprehensive refresh that consolidated and updated 5 separate sets of court rules governing ADR.
5 separate sets. That implies significant previous fragmentation.
It does. What was the benefit of that massive consolidation?
It was a periodic but vital effort to modernize standards. For example, they codified continuing legal education, or CLE requirements for court-appointed mediators.
Ensuring that even veteran practitioners have to stay current.
Exactly. On new legal developments, new ethical standards, they updated procedures for clerks' court mediation and revised the standards of professional conduct. This ensures that a mediator handling a family financial case is operating under the same clear rules as one handling a general civil case. It's all about consistency.
And New Jersey took a very similar approach, but focused specifically on its own court staff.
Yes. New Jersey, effective May 1st, 2025, overhauled its court-annexed ADR rules by creating a unified credentialing and training standard for all court staff who serve as mediators or hearing officers.
Because historically, they had separate, potentially overlapping rules for staff handling different types of cases.
Exactly. Child support, domestic violence, general civil cases.
So by consolidating these under a single rule, what is the ultimate benefit to the client who walks into, say, a family court mediation session?
The benefit is consistency and quality assurance. If a court staff member is mediating a domestic violence case or a child support dispute, their training must now meet the same unified high standard across the board.
So it simplifies administration for the court.
But more importantly, it ensures that vulnerable parties in these high-stakes cases are dealing with staff who have consistent, up-to-date expertise. It prevents those gaps in competence or professionalism that could emerge from having all these disparate training regimens.
That wraps up our detailed look at the incredibly active 2025 legislative and policy landscape for dispute resolution. Okay, let's synthesize all of this now. Based on everything we've unpacked, from the federal level down to the really technical rule changes, what are the 3 major overarching trends that define this year?
I think we see 3 powerful, interconnected forces that are really shaping the future of mediation.
The first one, which surfaced again and again, is this dual motion of mediation expansion, but coupled with targeted narrowing.
Yes, mediation is unquestionably expanding because state legislatures are mandating it in new, high-volume sectors. You see it in the short, firm deadlines in Texas health billing and the movement toward presumptive mediation in New York family court.
And it's being formalized by these big legal acts like Connecticut's UMA and UCLA.
It is. This demonstrates a real faith in the process.
But the narrowing is the concerning part, because that shows where the policy battles were lost.
Exactly. The narrowing happens when powerful industry groups achieve these legislative carve-outs, which create complexity and inefficiency. The clearest example is the California lemon law reversal, which makes mediation opt-in for manufacturers, thereby limiting its accessibility.
And the Florida HOA proposal, which would eliminate a necessary pre-suit barrier.
That's another. This duality just shows that mediation is a highly contested policy space, and its application really depends on lobbying power.
Okay, the second trend seems to be a relentless, sometimes aggressive focus on efficiency and judicial resource preservation.
Speed is the currency of the 2025 reforms. Lawmakers are obsessed with clearing court dockets. Every single one of these changes, from the Florida settlement rule simplifying how agreements get executed to the tight 90-day deadlines in California's original lemon law, it's all designed to force resolutions sooner.
So the underlying legislative message is clear. The judicial system is saturated.
And ADR is the fastest, most effective tool they have to unclog the courts.
And finally, the third trend, this persistent push for professionalization and uniformity.
And this is so critical for the long-term credibility of ADR. If the courts are going to offload disputes to mediation, the public has to be able to trust the process.
So California's voluntary certification, Connecticut's UMA, providing that clear statutory privilege.
And New Jersey's effort to unify training standards for court staff, all these efforts ensure that mediation is no longer seen as some soft option, but as a rigorous, high-quality, and dependable component of the justice system.
Okay, so we've covered all the technical shifts, but what does this all mean for you? Why should the average consumer or employee care about these technical legal reforms and all these acronyms?
Because these shifts directly determine your access to justice. They determine your timelines and ultimately your cost of resolving a conflict.
So if you buy a new car,
your recourse depends entirely on your manufacturer's opt-in status in California. If you are an HOA resident in Florida, you might lose your cooling off period and face immediate, costly litigation over a pretty trivial dispute.
Understanding these rules means you're prepared.
You're prepared. You know the deadline to file a surprise medical bill claim in Texas, and you understand the ironclad confidentiality that's protecting your personal concessions during a New York custody mediation.
This entire deep dive just shows us that mediation is not static. It's a dynamic battleground of policy, efficiency, and access to justice. It's constantly being reformed, sometimes in surprising and contradictory ways.
And that leads us to our final provocative thought for you to consider. The recurring policy debate, whether to eliminate mediation, like in the Florida HOA bill, or to expand it, like in New York Family Court, it forces us to grapple with a fundamental question about fairness.
And that question is,
When does the opportunity for informal, comprehensive resolution become merely an unnecessary, time-consuming barrier to justice? Is mandated efficiency always better than the opportunity for true, long-lasting communication?
that really is the core conflict, because the cost of bypassing that structured negotiation, the cost in money, in time, and particularly in the enduring nature of the resolution, that can be immense.
It can.
We often forget that the structure of mediation itself, that mandate to just talk and compromise, is a value that we lose when we jump immediately into adversarial litigation.
The listener should really contemplate. If we remove the step that compels two entrenched parties to just sit down and communicate, what is the ultimate financial and social toll of simply replacing that conversation with immediate, expensive, and polarizing legal warfare?
We may gain speed.
But we risk losing the chance for genuine peace.
A heavy but essential thought to chew on as you navigate the changing landscape of 2025 dispute resolution. Thank you for joining us for this extensive deep dive into the policies and reforms shaping how we settle our differences.
It was a pleasure unpacking this complex stack of sources.
Until next time, stay well informed.